Do cases get overcharged by the police department or by the DA's office in an effort to get you to take a plea? This is one of the questions that we've gotten. In my experience, no one overcharges cases in order to force you to take the plea. But what does happen is cases get charged, and then the investigation done by the defense attorney or the investigation done by the DA's office actually determines that the charges should be lower. It's much easier to charge and then drop charges or dismiss charges than it is to under-indict a case and then have to go back into the grand jury to get the additional charges added on. I generally think the DA's office tries to do a good job. They try to do a good assessment. They look at what is the fact pattern and what are the corresponding charges. But by the time the case goes to grand jury in New York State, it's been there for 5 days, 6 days. So it's a very short investigation. So they may not have the full picture by the time the indictment happens. And again, it's easier to take charges off than it is to put charges in. And I cannot imagine just the prosecutor sitting around the table and going, let's add some more charges. Let's overcharge to force a plea. I do think the time that they have to actually indict the case is rather small in terms of the 180 applications that the prosecutors have. So the investigation may not be fully developed, but ultimately if the case is overcharged and a subsequent investigation reveals that the case has been overcharged, the prosecutors or the judge will either dismiss the top counts or they would just offer a resolution to lesser counts. But I don't think anyone from the jump is like, let's overcharge in order to force a plea. That's not how the system works.